So let's talk now about the second part of language and vocabulary. And this is the question I want to ask, or I want to think about, is why? Why do we have a focus of language and vocabulary and language development and English language learners in public schools? Why does this even exist? Why do we do this? Well, have you ever heard of Lau versus Nichols? It's a Supreme Court case from 1973. And this is the foundation upon really what laid the foundation for the emergent bilingual reality in public schools in America. So basically in San Francisco in the early 1970s, you had this lawsuit that was filed. There was a large Chinese-speaking population in the school. And so mentioned in the lawsuit is 1,800 Chinese-speaking students. So they sued the San Francisco School District because even as the school district admitted, the students were not able to meaningfully benefit from the school because they didn't understand the language. So the case actually went through two federal courts. Both the lower federal courts ruled in favor of the school, saying that according to the Equal Protection Clause that's in the Constitution, that because they were receiving the same instruction, they had the same materials, the same teachers, that they were protected under Equal Protection Clause. They were getting the same education. But what the attorneys and the families of the Chinese-speaking students were saying is that no, that basically they were being discriminated based upon their national origin national or minority, which is part of the 1964 Civil Rights Act, and therefore implied in that is a discrimination against language. And because they weren't able to access any of the education, then they were asking the courts to act on their behalf to make the school system do something to address that need. And so once it went to the Supreme Court actually ruled unanimously in favor of the students. So what I want us to do now is actually I'm going to play a few clips from the arguments from the Supreme Court that so you can hear the arguments from the side of the attorneys that were arguing on behalf of the students. So let's listen to that.
We'll hear arguments next in number 726520, Lau and others against Nichols.
Thank you. Mr. Chief Justice, may it please the court, I wish to devote the 20 minutes of my opening argument to the constitutional issues raised in this case. I will then be followed by Mr. J. Stanley Pottinger, the Assistant Attorney General of the United States, who will address himself to the statutory violations of the Civil Rights Act of 1964. The issue in this case concerns the discrimination suffered by nearly 1,800 non-English speaking Chinese students in San Francisco in the provision of educational benefits and opportunities. Both the Federal District Court and the Ninth Circuit Court of Appeal below were satisfied that so long as the San Francisco school system provides the same instruction, the same materials, the same teachers to all students, then Equal Protection Clause is satisfied, regardless of the fact that these students, since they do not understand English, and since they are sitting in classes where English is the language of instruction, regardless of the fact that these students cannot learn.
I'm going to interrupt you.
What is your ultimate complaint? That English should be taught in these schools?
Well, what we would...
Or that the instruction should be in Chinese?
Oh, no. Our goal is the same announced goal that the school system in the state of California has made. Our goal is that we want these students to be taught English and to understand English so they can have the type of mastery of English which our society requires. The problem now is that they are being taught in a language they do not understand. And we would like the school system to do is to take whatever steps are reasonable, and this of course is within their province since they are the experts in this area, to take whatever steps are reasonable to guarantee that these students are able to benefit from the instruction they're given.
So you would have the same objections they taught them in Chinese?
If the school system decided that teaching them in Chinese was the most effective method, that would be a bilingual method, Your Honor. If the school system decided that teaching them in Chinese...
You wouldn't complain if they taught them in Chinese?
So long as they would be able to understand the language of instruction which they're getting throughout the school system.
I thought you said you wanted them to learn English so they could survive in our society.
Well, under the laws of the state of California, the school systems must primarily teach them in English. So the school system would not teach them totally in Chinese. The school system might wish to employ Chinese-speaking teachers in a bilingual setting. That is their choice. Our complaint is not with methodology. We're not asking this court to get involved in pedagogical questions. Our complaint is that right now, the school system is utilizing no methods. Based on their own admissions, if I can refer the court to this court has always been concerned with looking beyond, if you will, surface equality. The Ninth Circuit was satisfied, as was the lower court, that surface equality satisfied the protection clause, giving everybody the same thing, even though some cannot benefit from it. But this court has always shown, in cases even decided before Brown versus Board of Education in the education area, Sweat versus Painter, McLaurin versus Oklahoma Board of Regents, that there's something in education, that education is the essence, if you will, is communication, an interplay of ideas, an ability to discuss. Mr. Justice Frankfurter, 20 years ago, made, I feel, a very acute observation in the Dennis versus United States, in a dissenting opinion, when he said, quote, "There is no greater inequality than the equal treatment of unequals." And I think the Ninth Circuit is ignoring the truth of this observation by failing to recognize that education is not solely a matter of physical presence in a classroom. That although the 1,800 petitioners and all other students in San Francisco do receive the same materials, the pages are blank for these petitioners. The print conveys nothing.
So I find this very fascinating discussion or argument from the attorney. So some of the quotes that I pulled out that I think are important to think about, and these are not really in order that came in the argument, but let's look at this this first one, this idea of surface equality. This is what the lower courts held, that just because the students are in the same classroom, they have the same materials and the same instruction, that they're getting equal treatment. So what the attorney was asking is that it had been the history of the Supreme Court to look beyond surface equality and to think about what does it mean, as he quoted one of another justice that had written an opinion in a case that the court ruled against, but that there's no greater injustice than the unequal treatment of equals. And so, did I say that right? There's no greater injustice than the equal treatment of unequals. That's it. I got it backwards. So basically saying that even though emergent bilingual students are in your classroom, just physically being in the classroom is not enough. One thing that I found, if we look at this number 3 right here, this is the one that I found fascinating. And here you have legal experts, you have Supreme Court justices, often educators. We just are often, unfortunately, have it beat in our heads just to do what you're told, right? And we're not really challenged to think for ourselves. And look at what they're saying here in this argument in the Supreme Court. And so what he's saying is we're not going to tell school systems what to do. He says what we would like the school system to do is take whatever steps are reasonable. And in this course, it is within their province, so within their realm of control, since they are the experts in this field, to take whatever steps are reasonable to guarantee that these students are able to benefit with the instruction they are given. I have worked in supporting emergent bilingual English learner students for a long time, and I think this is really a fantastic summary of the reason behind the work that we do to support English learner students. And what I really like about this is that the court is deferring to the expert advice or the expert problem solving of educators. So again, this is 1973. So as you can see, if you take this idea that schools are going to be obligated to do whatever is reasonable, to make sure that students can benefit from the instruction they're given. That's the key thing. So then out of this, you have sheltered instruction. You've got researchers like Jim Cummins, Stephen Krashen, who are doing a lot of research on second language acquisition. This becomes a thing in public schools, is how do we address this concern that we've got students in our class who cannot benefit from the instruction. So we know now that a student merely sitting in the classroom receiving the same page is not it's not equitable. It's also not reasonable, and they're not going to benefit from the education. And the whole point is that they're there to benefit from an education. So that's where you have all of this emergent bilingual, English learner, all of these strategies, they come out of this. Bilingual education comes out of this, is that in public schools in America that receive federal funding, this case really came down to the fact that the local school system was receiving federal money. And because it was receiving federal money, it was in direct violation of the Civil Rights Act of 1964, is what they didn't make it a constitutional issue in this case. However, there's another case that we can talk about later that does make it to the constitutional issue that deals with emergent bilingual students. But as far as this case really sort of, in my opinion, laid the foundation for why we have the identification of English learners and the instructional strategies and the focus on helping to develop language, because the end goal is that these students can benefit, as they say, from the instruction that they're given. What we don't want is students like number 4. We don't want the students like they're referencing here, the 1800 students. Even though they do receive the same materials, the pages are blank for these petitioners. The print conveys nothing. That's not what we want for students in our classroom. And so what we're going to be getting into the next video is the how. How do we do this? How do we make sure that they can benefit from the instruction that they're giving? And so that's what we're going to look at next.